We are going to be getting questions of clarity in terms of the DMRE's presentation with regards to the upstream Petroleum Resources Development Bill, in particular post the submissions written that have been made and supported by oral submissions. I must say, particularly from the same executive, especially executive, obviously from a different section of the executive. Honorable Deputy Minister, then we will be going to DMRE to give us their response with regards to the proposals that were made by the stakeholders. Can I give to the department, Honorable Deputy Minister?
Thank you so much, Honorable Chairperson. Good morning to all honorable members. Thank you so much for giving us this opportunity to come and present before the Portfolio Committee. I will then hand over to the DG to then take us through the presentation, and he's going to also assign the relevant official to get into the details of the presentation. Thank you so much, Honorable Chair. Over to you, DG.
Thank you, Honorable Deputy Minister, and good morning, Honorable Chair, honorable members, support staff of the Portfolio Committee, and colleagues from the department. Chairperson, I will not waste your time. The presentation will be delivered by a colleague in the department who has been extensively involved in the consultations for this bill, and that is Dr. Maseko. Dr. Maseko, over to you.
Thank you, DG. Good morning, Chairperson. Good morning, Honorable Deputy Minister. Good morning, honorable members. We were meant to share the presentation, but they haven't given us the ability to share the presentation, DG. So if we can be assisted, we were trying to share, but we can't.
You were given the right.
They gave me, not you. It will be ready. Oh. Yeah.
Dr. Maseko, I understand you are given the rights to share. Okay.
DG, can you see it?
Yes, ma'am.
Oh, thank you very much. So the presentation outlines, we will focus on progress to date, and we will also focus on the summary of the key concerns with the responses from responding to the comments sent by the public and stakeholders after publication by Parliament. We will also look at the concluding remarks. We all are aware that in November 2019, Cabinet approved that the bill be published for public comment. That is the UPRD bill. And then it was published on 24 December 2019, ended in February 2020. And we had received about 60 written submissions from interested and affected stakeholders. And in April and May 2020, the DMR conducted virtual consultation on the draft bill. Members will note that this is the period where we had COVID, and this included industry representatives, legal fraternity, BEs, and NGOs. All submissions were received and considered where possible. And the bill went through cabinet, and Parliament then published it for public comments on the 24th of June 2022, and written submissions were expected before the 29th of July 2022. To date, Parliament had received about 15 set of comments, which they forwarded to the department, which we will present today. So the presentation will unfold in the following manner. So we have looked at the comments from the public, and what we did, we sort of analyzed the comments, and where there are common inputs, we have summarized the inputs, and we will start with the definitions. So there are key definitions that we thought will have an impact in the bill. The first one being the carrying holder, and the concern that the stakeholders are raising is that the petroleum rights holders exclude Black persons, meaning our definition exclude Black persons. And we do believe that it is the object of the bill, among others, to create a conducive environment for Black persons to participate and meaningfully participate in the industry. And therefore, Black persons cannot be carrying holders. The next definition that is of concern is the definition of Black persons, where they are saying that the section is in contravention in terms of the equality and the direct violation of human rights. And we are saying that the bill is intentional, and it is not, it is in line with the Constitution in order to redress past imbalances and further enhance government policies and legislation. In line with the Constitution, we are saying that our definition, we believe, must stand. It must exclude Black persons. And then in terms of carried interest, which is the next definition, we know that the bill provide for 20% carried interest for the state for any petroleum right holder except Black persons. And also the other issue here, their concern is that we need to sort of take the 20% and divide it in half, not in half. 15% goes to the state and 5% goes to Black persons. And we are of the view that Section 34 provides for that 20%, and we believe that it is it's a proposal that will advance the development of petroleum sector, and meaning that the state has the capability of ensuring that whilst they are carried, they will have the interest of all South Africans and benefit, and the people can benefit from what the state would have gained from that 20%. And also that in Section 31, Black persons are provided for in that they have a minimum of 10% undivided participation interest. And we believe it is sufficient, and they can meaningfully participate through that. So we don't support the view that the 20% free carry interest be shared in that manner. Then we will move to comments made on the objects of the Act. The first comment that was made, it was made in Section 2B. We'll recall that Section 2B gives effect to the principle of the state's custodianship of the nation's petroleum resources. The issue is that there is a view that this will have a direct contravention of the Constitution, as the state will have sole right over resources. And we are of the view that we don't see any enabling of corruption in the way they are saying it. We believe that the state should manage and the development of petroleum resources optimally for the benefit of all South Africans. The other comment relating to the object is on section 2D. Section 2D is meant to expand opportunities for participation by Black persons so that they can actively participate in the petroleum sector. And therefore, we don't see any infringements and violation of human rights as being said by the stakeholders. So we are also of the view that that section also allows us to redress the imbalances of the past and to ensure that Black persons participate meaningfully in the petroleum resource sector. The next one is 2J. 2J provides for the acceleration and exploration of, provides for the acceleration of exploration and production in the petroleum sector. The benefit of all citizens has been removed as accelerated exploration will cause severe damage to that. Obviously, there can be a negative impact on the environment due to exploitation of petroleum resource sector, but the bills seeks to ensure sustainable development of petroleum resources, which include environmental management, whilst advancing socio-economic conditions of South Africans. And we are of the view that we have provided enough in terms of environmental management as we will be working with DFFE through provisions of NEMA. The next comment is on object 2K. 2K provide for the framework for developing third-party access arrangements to upstream petroleum infrastructure. And the comment is that this framework should be made available prior to commencement of the bill, so that the state will not be able to limit transparency and review the actions of the state and related bodies. We are of the view that section 68 does provide that fully the framework, and it also outlines the terms and conditions by which parties must use to work together through an agreement which will be approved by PASA. So the third-party access of upstream petroleum infrastructure is really fully catered for in section 68. So we don't understand why we should make the framework available whilst the act is very clear. Then we will move to the comments made on the sections themselves or the provisions of the bill. There is a comment made on ministerial powers, that is section 32A. Section 32A in the bill provides that the minister may grant, issue, refuse, control, administer, and manage any reconnaissance permits, permissions to remove all other permits and petroleum rights. And there is a comment that minister should not have those powers as stipulated in the section, and that the government will ensure that the state gets what the state wants at the full cost of local communities. And there is no link in terms of accountability. So it is just said that minister will not be held accountable. But we are of the view that the processing of application of all the rights from reconnaissance is done through PASA and mini proof, looking at discretion. And there is a level of accountability that minister will have to have as he will then make those decisions in the recommendations. There is also a comment on the legal nature of petroleum rights. This is provided for in section 5.1 and 5.3a, b, c, and d. 5.1 outlines that the right granted in terms of this act is limited and is a limited real right in respect of the petroleum blocks to which the right relates, meaning it is not absolute. It must be met by the right holder. So we believe that the legal nature in this section has been fully provided, because the section provides for the terms and conditions. It also provides for the rights and obligations and the requirements that the applicant must meet. So the legal nature is fully outlined in section 5, 1 and 3, ABCD. So the next slide will focus on 2 issues. The first one, we will deal with the administration of acreage, and the second part will deal with the functions of PASA. Section 8 of the bill indeed gives powers to PASA to administer the acreage, and by notice in the Gazette, designate certain blocks, including shale gas acreage, over which the limited knowledge of geology is frontier. So this section will perpetuate an open season for petroleum exploration in South Africa. So our view is that PASA should do that. They should administer the so that there is an orderly development of people for all people, allow for an open season. The next issue relates to the functions of PASA in the very same slide. That is the second section 10F, 10G and 10M. In the bill, section 10F is relating to functions of PASA, which talks about the receipt and evaluation of applications for permits and rights, and PASA therefore will make a recommendation. Section 10G speaks to enforcement and compliance, and that PASA must regularly report. And 10M, they must receive and review application for environmental authorization in terms of NEMA. So they view that PASA is incompetent in terms of some of the technical functions by the stakeholders. We believe it's not necessarily so true, because the PASA has already been doing these functions in terms of the ones that I have outlined of administering the licenses and also monitoring compliance. It's practice that they have been doing. So we don't see any challenge about PASA's functions in terms of those issues that they have raised. And we believe that in terms of the environmental issues, our minister is the competent authority for environmental authorization, whilst the DFFE minister is the appeal authority. So we are well equipped working together with DFFE to address environmental issues. The next slide deals with licensing rounds and consultations. So in section 15 and section 37, 15 provides for competitive administration licensing round for petroleum right, meaning that the minister in section 15 may, by notice in the Gazette, invite applications for petroleum right in respect of blocks or blocks specified in the notice. And in that notice, he will prescribe, or she will prescribe the notice, the period, and that the application must be lodged with PASA. And the notice also has guidelines in section 15. And then in section 37, there is an open licensing round where minister will issue a notice in the Gazette and invite open applications for petroleum rights in respect of those blocks with timeframes, and the application received will be processed by PASA. And there is a clear delineation in that if 2 right holders apply in one day, those 2 applications will be considered. And then if the one applies today and the one tomorrow, it will be that the one that applied a day before becomes the first. So we are of the view that minister has provided ample opportunities for applications, and it is the intention of the bill to move away from a first come first served basis. They are talking about that, why are we not putting the application in terms of the MPRDA? So we are of the view that this bill has really provided for the 2 phases of applications, and will cater for all those who want to participate in the sector. Section 19 and 20 relate to consultation. So section 19 deals with the consultation of interested and affected parties by the Petroleum Agency. We are all aware that the scope of PASA obviously says they must, once they receive the application, and they can look at how the consultation was done in the report that would have been given by the applicant. And if they feel that the report submitted by the applicant is not enough, they can then go and do a second round of consultation with the affected parties. But the stakeholders are saying that they use the word that is used in that section, which says may, we leave that to the discretion of PASA. We are of the view that PASA really has been doing this, and we trust that their competency and their ability to look at the consultation reports, they will do due diligence and make sure that if there is a need to conduct a second round of public consultation, that is done. Section 20 addresses the consultation with affected parties by the applicant. In this one, the issue that the stakeholders are raising is that there is a need to consent by the landowners and lawful occupiers and affected parties. They must consent before consultation is held. We are not opposed to that they should agree to the process of consultation, but we are saying that we will provide for that consultation process on how it is to be done in the regulations. So that issue is a matter that we will address, and we do believe that any consultation process should go with consent. The next part deals with participations by Black persons, and the second part of the presentation will deal with reservation of blocks. We know that Section 31 deals with the issue of Black persons participating in the petroleum right. And there is a view that whenever a petroleum right holder cannot comply with the requirements of ensuring that they incorporate Black persons, there is an extension that is given of 30 days for them to comply, of 2 years, sorry. The extension is 2 years, and the stakeholders are saying that extension of 2 years is not sufficient. And we are of the view that that needs to be regulated, because an open-ended extension goes against the anticipate. I mean, the delay over, we will not see the impact in terms of Black persons participating. Section 32 outlines the reservation of blocks. We know that we have assigned, we have make sure we have there is a legal issue in terms of affording Black persons to participate by designating certain blocks. So minister will at a certain point designate blocks that will be meant for Black people, Black persons. And the stakeholders are saying that it is somehow the legal benefit is on the basis of race. And why let one race participate or benefit from these designated blocks? So in order for us to effect transformation in the petroleum sector, we had to come up with certain initiatives or certain provisions in the bill that the Black persons can be able to participate. Those designation of blocks will enable that participation. In terms of Section 34, so we're dealing now with state participation. So this is the section that I spoke about related to the definition of state participation, wherein we are talking about the assignment of 20% carried interest in petroleum right for the state. And the view here is that this issue of the carried interest by the state in a petroleum right, it is a relatively vague and very unspecific. And the next issue is that it's a misnamed tax. There is a belief that we are just bringing a new tax in this sector, being an akin to nationalization. So we have responded to those issues in the manner that, firstly, we do believe that the 20% carried interest is important, and it will ensure that South Africa optimally exploit oil and gas And by doing that, the state has the capacity to make sure that all people benefit rather than if it is given to an individual. And then the issue of the tax, it is not a tax because the holder is entitled to recover costs. We are aware that once they have done the 20%, they can recover costs from between 50 and 100 when the production has been maximized. And then the last part about the custodianship, we do believe that the resources in the country rest within the state, and it doesn't mean that the state is the owner of those resources. And custodianship does not bestow ownership. It is just an issue that the state must manage, and they must ensure that they administer the resources carefully and orderly so that all these issues that we are talking about participation of other people and also the environmental issues are taken care of. We believe that fully the state has a duty to do that. And then the next part speaks to the strategic stocks, section 36. So there is a provision in terms of section 36 that requires that the petroleum holder must sell a percentage of petroleum strategic stock of the country stipulated in the bill, and in light of the decision, and it is submitted that of the view that the mechanisms which will enable for the state to have strategic stock will be done through an agreement. Details on how that can be done. And then where parties are aggrieved, there is a process of arbitration. So there should be an agreement between the parties and how that a strategic stock sale is conducted in a manner that doesn't disadvantage the right holder. So there are issues relating to, we had an engagement with DFFE where they were raising a concern that in the NEMA, there isn't any mention of a petroleum right, which we agreed. And further to that, we had then an engagement with the officials from DFFE, and we have consulted the state law advisor, and we are going to be enacting a general clause in the bill to ensure that that petroleum right issue is catered for. So this matter has been almost 95% resolved. We will then rely on the state law advisor to ensure that the bill is amended accordingly and that general provision, that general clause is provided for. We move then to section 42 and section 48. Section 42 deals with notarial execution, and section 68 talk to third-party access. 42 provides for notarial execution of permit, rights, or deeds, and that the right holder must, within 30 days of receipt of granting of the right by PASA, must move to the next phase under the right within 30 days. And then an extension of 30 days is provided if they can't meet the 30 days. So meaning once there is an approval or authorized application by PASA, they must move to a notarial process. And the view of the stakeholder is that this is a very cumbersome process in that there is also an administrative the delays can be simple due to administrative availability of authorized persons, and also that this can make them fail to comply with the aforementioned short time of 30 days. So unfortunately, we had a case in the department by Mawetsi, wherein on the mining side, it was said that once an approval is granted for a right, there is no need to wait. The execution or the notarial process should start. So unfortunately, on this one, will be found wanting if we make more extension than the stipulated period in the bill. Section 68 deals with third-party access on infrastructure. So the bill provides that the third party access to petroleum upstream infrastructure be done by PASA, and then there are tariffs within which that process should be undertaken, meaning between the two parties, the one who is giving access and the one who wants to access the infrastructure, so that there is a optimal use of those infrastructure in the industry. And the view of stakeholders is that NERSA is not the regulated authority that must deal with the tariffs in relation to that third-party access. We are saying that whilst NERSA is mandated to regulate the downstream, the tariff that NERSA regulates is for transmission and distribution of gas, not for upstream pipelines. So we will have to have a tariff that PASA will have to do to ensure that the pipelines, the tariff for third-party access is appropriately executed, or it is formulated. The general comments. So we did receive some general comments in the bill from several stakeholders. And the first one is that they have a view that the bill ignores the climate change crisis. We note that their report, their a United Nations report and other reports in the country that deals with climate change. Most of the stakeholders that commented on that, they believe that we shouldn't promulgate the bill in its current form. We should have an appropriate framework for just transition and moving away from fossil fuel extraction. Our view is that how we have structured it, it will ensure that petroleum resources are developed in an ecologically sustainable manner, while we seek to uplift the socio-economic conditions of South Africans. And the bill further gives effect to Section 24 of the Constitution. And environmental issues, as mentioned, I have mentioned that we have an agreement on how we will address the environmental issues, which we are already using within the mining, using MPRDA. So the department has the capacity to address environmental damage or environmental consequences that may arise out of exploitation of petroleum resources. The next part is about inclusion of BE companies in the industry. We are saying that Section 31 provides for a minimum of 10% undivided participation. So undivided participation meaning commercial terms of interest by black persons. That for us is sufficient for making sure that we include BEs in this sector. The last part being that we should grow local skills and expertise, which we know that in the bill, there is an object that talks to promoting local employment, skills development, technology transfer, and national industry participation through supply of goods and services. So that object will enable the state to ensure that we grow local skills by many avenues. And we do believe that here, public-private partnerships will come a long way so that we enhance the skills in the petroleum sector. So in terms of our concluding remarks as a department, we are saying that passing this bill is critical for the development that the industry, the bill will contribute hugely to energy security, and there will be a fair share of revenue in the industry, which will benefit the people of South Africa. I thank you, Chairperson.
Chairperson, thanks, Dr. Maseko. Chairperson, that's the presentation on the analysis and that the team has done on the comments that we had received and the response to some of those inputs from the public. Chairperson, I'm aware that we are struggling this side with the network this morning, and I understand the Deputy Minister, the system kicked her out, but I've noticed that the Minister is in the meeting. I will then hand back to the Minister.
No, I was in the meeting when you started. I'm still in the meeting. I think that is the presentation we have tabled. I must hand over back to you, Chairperson.
Thank you, Honorable Minister. My apologies. I honestly did not see I went through the names, but I couldn't see your name. But my apologies on that. Yes, it was brought to my attention by the Secretariat of the committee that you are in the meeting indeed. It was never intentional. Okay. On that note, honorable members, are there any questions of clarity, not views or our position with regards to the bill? Remember, we're dealing with the bill. There's still a long process to follow. It's just getting a clarity so that when we deal with the bill on our own, at least we are clear on what is the meaning of what is being tested. I see the hand of Honorable Lorima. I see the hand of Honorable Zungula. Is there any other hand? I see the hand of Honorable Matogwe. Is there any other hand? Okay, in the absence of another hand, can I give to Honorable Lorima and then Honorable Zungula, and then it will be Honorable Matogwe.
Thanks, Mr. Chair. Just 3 questions. The first one was just a general one. As a result of these written submissions, did you change anything in the bill? And if so, what did you change? Second question is a specific one from slide 12, section 20. Question is, why leave it to regulation? Why not put it in the legislation to greater certainty? The following question is from slide 15. Again, a similar one. Section 36, why is it not stipulated in the bill? This, to me, leaves it open to negotiation. And negotiation means that it opens the door on the possibility of a sweetheart deal. And this is exactly what people complain about, and what the government acknowledges is a lack of certainty in our legislation. So why are we proposing another bill with uncertainty written into it? Thank you, Mr. Chair.
Honorable Zungula.
Thank you, Chairperson. Greetings to yourself, the Minister, the Department, and my colleagues. Mine is very quick. I just to find out ordinary the Department public hearings put on this particular the department on the bill virtually. Now I wanted to find out, in accordance to the perspective of the department, is that effective consultation, given that ordinary South Africans to platforms. Yeah, so I feel this is important because when we do our own public hearings, we do not want a situation whereby the citizens who are going to meet may feel left out and may feel they did not have any participation on the bill because of the lack of access to those platforms in which they could express their views. Thank you, Chair.
Okay, Honorable Matogwe.
Thank you, Chair. I think Honorable Lorima has partly covered me in aspects where the bill either refers to other regulations, other policies, as opposed to actually making explicit clauses on the bill. So I'm just interested in that, not only the 2 that he spoke to about, but also the impact on climate change and also environmental impact, in terms of why is that not actually included in the bill, and there's a reference elsewhere. And then the second one, I think it's on the issue of PEE and the inclusion of participation of Black people. And I'm interested in why is it that if we're looking at undressing the legacy, if I may put it that way, of colonialism and all of that, And we are of the view, or we also understand that Blacks constitute roughly 70% of the population. So what informs 10% as the allocation of Black participation, as opposed to maybe a slightly higher percentage? Thank you, Chair.
Okay, let me give to the Honorable Minister and the team to provide the answers. Now, on the issue, I take note, the reason I was not raising a concerns, DG, with regards to the network challenge. I was not sure whether it's on my side or on your side. But also, I think we're all aware that in most cases, when we have these meetings, some will still be under the conditions of load shedding. But I think the overall gist of the presentation, at least, was heard by honorable members. Honorable Minister.
Thank you, Chairperson. Whip of the Portfolio Committee, DM, DG, and the team, honorable members. I will allow the team to give answers to the questions. I will fill gaps if there are anything left at the end. DG.
Thanks, Honorable Minister. Dr. Maseko will take the detailed technical questions, and if there's anything, I will come before I hand over back to the Minister. Dr. Maseko.
Thank you, DG. Thank you, honorable members, for the questions. I will start with Honorable Lorima. The first question was a general comment that did we change anything on the bill? The answer is no, we did not change anything. The next question was on slide 20, where he was saying, why are we leaning or mostly on regulations? And we are of the view that we are not able to put all the details in the act. We will provide details step by step in the regulations. So we don't believe that anything is lost, but we hear him from that point. We didn't hear much on section 36, the issue of strategic stock. I think we had a network issue. I didn't get the question. I just had uncertainty in the provision. But maybe if you can clarify that question on the strategic stocks. Maybe let me just move to Honorable Zungula, where he was concerned about the consultations which were done virtually. Unfortunately, we believe that was the most suitable or the most suitable, conducive method to do consultations, because the bill was already in process and COVID hit us, and we couldn't just leave it without processing it further. So we tried our best, and we can see the public, even after our first gazette, they had really give us comments in the bill. So we are hoping that going forward, as the Parliament goes through parliamentary sessions with the public, we will get more information. And then the last set of questions was more on issues of climate change. Why are we not sort of dealing with it in this bill? The issue is that the environmental management in the country is addressed through the DFFE, and we can't, as the department, start with new requirements in terms of environmental management. I mean, we are all one government. So the issue is that what we are doing on it has been working, and the department needs to derive. Don't see any issue in managing environmental issues and climate change, which are brought about by climate change. We believe that we will be working together with our sister department to address that. The other issue is the issue of participation of Black persons. Why are we talking to 10%? Our view is that the section provides for a minimum of 10%, meaning that that can be expanded from 10%. It can be less than 10%, but it is 10% and above. So I will await Honorable Lorima to. Oh, okay, I think one of my colleagues, Honorable Lorima, got it. Why is the percentage not stipulated in the Act in terms of the sale of the strategic stock by the Petroleum right holder to the state? We are of the view that in that section, there is a clause that talks to that the parties will have an agreement. And in that agreement, the terms and conditions of the sales will be stipulated, and that will allow for the percentage between the two parties to be agreed upon, unless there is a view that we need to have a minimum percentage of the sale. That can be another discussion, but we wanted to leave it to the parties so that we don't necessarily tie the parties, but I think we are open for more inputs on the issue of the percentage. Thank you.
Thank you, Dr. Masayoka. Chairperson, I believe the colleagues have actually addressed all the questions. I think from my side, maybe just to re-emphasize the point that Dr. Masayoka made around the dealing in detail with environmental and climate issues in the bill, in that, as she had indicated, this is obviously the competency of DFFE, but also because they look at these things in a holistic manner. So if we create a regime that is different in our bill, we may have a challenge later on when they change things on their side. You find that there is a contradiction between what they're driving and what is actually contained in the bill. So yeah, I think those are the responses from our side, Chairperson. Back to you, Minister.
Thank you. I will just give two answers. I remember Matokwe asked why 10% for BEE and 20% for the state. Actually, when we make provision for 10% provision, we don't exclude the BEE from negotiating whatever percentage on their own and find that percentage. And the reason for that is, one of the things that we think, I think 10% is reasonable. The 10% in the mining charter is divided between communities and workers. And it's a good foundation. If any of them want to increase, they can increase it. But the reality of the matter is that business, we must put our skin in the fire. If we don't put our skin in the fire, we're not going to be successful business people. Even if we're given 50%, we'll collapse it. That is the only point I want to make. Secondly, the question that says why everything should not be in the legislation. One of the weaknesses of any omnibus legislation is that it is less effective than a focused legislation. But we're here to listen to the directive of the Portfolio Committee. Thank you very much. Back to you,
Thank you, Honorable Minister. This process, unfortunately, is not necessarily the same like other processes that, from a Portfolio Committee point of view, undertake. I think when we are given answers, like you say, Honorable Minister, at the end of the day, it is the committee that will then have to express its views on the proposed, after it had followed all the required procedural processes as prescribed in the rules of the National Assembly on how to process legislation. And when these questions are raised, is that when the committee makes those recommendations, at least it moves from an informed point of view on what, from its own perspective, should be the approach or the issues contained in the legislation when it is finalized. I'm not sure. I hope honorable members have been able to get the clarities on the issues that they were raising with regards to the presentation. And if it is the case, can I then give the minister to make the closing statement from the department, and then we'll go to the minutes? Honorable Minister.
No, thank you very much, Honorable Chairperson. We always appreciate coming here because when we come here, you don't ask us what we want to hear. You ask many complicated questions. That builds us, and it instills confidence in ourselves. Thank you very much for this session again. Thank you.
Thank you, Honorable Minister Chen. Thank you, DMRE. Thank you, my honorable members. The process, as outlined, we will then, when we deal with the program for first quarter 2023, it will also contain the process to be followed as far as the legislation is concerned, and then other matters contained therein as an interactive session with regards to this. Like I said last time, it's still gonna be a tedious process that we're going to undertake. I was asked at some point, when do we intend finishing the process? We would have loved to finish the process as quickly as possible. Unfortunately, there are processes of Parliament itself that guides us. Failure to manage or master those processes will leave the legislation vulnerable and open to many challenges. If there are areas or errors made, they must be on the basis of not being able to detect them without any intention of doing shortcomings. So we're still gonna continue with this process until its finality, of which, when it is done, it will be taken to the National Assembly. The National Assembly, if it sees it goes through the National Assembly, it succeeds, it will then be taken for processes in the National Council of Provinces. So there's still a long way to go with regards to processing this piece of legislation. On that note, I noted Honorable Langa. I think it's a challenge all of us that will have with regards to connectivity and network challenges. Having said so, can we now go to the minutes?
We didn't distribute the minutes, Chair, to members.
Okay, you are prolonging our time. In that case, we will deal with the minutes in our next meeting.
Correct,
next
Chair.
week. Honorable members, the meeting stands adjourned. Thank you very much.
Recording